Today's presentation is titled To Warn or Not to Warn, When the Science Behind the Hazard is Controversial. I am Sonia Valdez, a Vice President of Claims at Medmarc. On behalf of Medmarc and today's presenters, Michael Shalhoub and Joseph Welter, thank you for joining us. A little bit about today's panelists. Michael Shalhoub is a partner and proven trial lawyer at the law firm of Goldberg Segalla, who focuses his practice on product liability defense for the medical device and pharmaceutical industries. In his more than 30 years of experience, he has resolved more than 100 cases at the trial stage and achieved numerous defense verdicts. His experience includes cases involving products liability as well as medical malpractice, business and commercial disputes, insurance coverage, construction accidents, and general liability. Mike is co-chair of Goldberg Segalla's Life Sciences Practice Group and a nationally recognized authority on product liability defense. Mike has been selected by his peers and clients for inclusion in the best lawyers in America and New York super lawyers for a number of years, and he was named among the top 25 attorneys in Westchester County and super lawyers several times. Joseph Welter is a partner and chair of Goldberg Segalla's Toxic Tort and Environmental Practice Group. Over the past 25 years, Joe has successfully defended the interests of companies and insurers serving as national, regional, and local trial counsel in toxic tort litigation across the country. Joe is a nationally recognized lecturer and author regarding emerging toxic tort issue. He is also the editor of Goldberg Segalla's Asbestos Case Tracker, which has been hailed as the go-to resource for significant asbestos verdicts and developments throughout the country, which was recently named as the ABA's journal prestigious Blog 100 and named Best Litigation Blog for 2006 by the Expert Institute in its annual Legal Blog contest. Joe possesses an AV rating from Martindale-Hubbell, the highest possible rating, and has been selected for inclusion in Business First, Who's Who in Law, New York Super Lawyers Corporate Counsel Edition. With that, I am pleased to turn things over to Mike Shalhoub, who will begin today's presentation.
Thank you, Sonia, and thank you and Medmarc for inviting us and giving us the opportunity to present on this topic today. It's one that I personally find very interesting, and I know that it's an important topic for the industry that we all represent. The issue of warnings and labeling in the FDA world is important. I do want to start by saying, though, that the title, To Warn or Not Warn When the Science is Controversial, we don't have an answer to that. All we are looking to do is talk about the law behind failure to warn claims and provide some considerations for people to think about where there's evolving or developing science. So we'll, where are we here? So I'm going to take a moment to get used to the slides. And for everybody else, good afternoon or good morning, as the case may be, depending upon your time zone. This is a short outline of what it is Joe and I will be talking about today, starting with the human factors considerations in failure to warn cases, what the legal duties are from a common law perspective, how FDA regulations affect those duties. We'll talk a bit about assessing and understanding scientific research, and then what we thought would be of practical use for this presentation would be to apply what we've talked about to the talc ovarian cancer litigation and controversy that's ongoing. It's a currently developing litigation, and then finally we'll finish with some lessons and takeaways. And with that, I'm going to pass it to Joe, who will start the presentation.
Good afternoon, everyone. This is Joe Welter. Just to frame the issue for our discussion today, we're looking at this from the context of a manufacturer who is manufacturing a product or has already manufactured a product and placed it on the market, and there is some underlying question as to whether the product causes some type of injury or some type of disease. And so the context of our discussion today is really when the science and the medicine is unclear as to that causal connection between the product and the injury or disease, what should a manufacturer do in terms of warning consumers about this potential harm? And there are a lot of different ways to look at it, and we're going to take a look in some different contexts as to how it is viewed, we thought the appropriate place to start would be from a human factors perspective. Now, for those of you who may not have had experience with human factors experts in this field, these are essentially people who study human behavior. And in the warnings context, these people have an approach for determining whether a product should contain a warning. If the product should contain that warning, what should it say? How should it be placed on the packaging? Where should it be placed on the packaging? Where should it be placed on the product? And so there's a whole science related to the warnings area from a human factors perspective. So, switching to the next slide, human factors experts start with a very simple threshold premise. And for them, any warnings analysis is to identify in the first instance whether any hazard exists. And without a hazard, there simply is no need to warn. And that's an important issue for reasons we'll talk about a little later in the presentation, because if the science is unclear as to whether there's actually a hazard, in other words, a causal connection between the product and disease, then the analysis from a human factors perspective may simply stop here. So the question from a human factors expert perspective would be, how do we go about identifying whether there's a hazard? And there is a specific approach. Techniques are available to research and determine whether a potential hazard may exist in connection with a product, and they involve a variety of different things. I highlighted published documents because, as we'll see as this presentation goes along, it's really the published documents related to the scientific literature that really form the basis for the analysis as to whether there's a causal connection between a particular product and a disease. And it's also worth noting, just as an aside, a lot of this approach here I actually took from a warnings expert who testifies frequently on behalf of plaintiffs, Dr. Michael Wogalter. We've had experience with this particular expert. We've deposed him in litigation. He's nationally recognized. His own handbook on warnings has the approach that we've often turned around against him in proving that no hazard does exist. So according to even a plaintiff's expert, one of the things you look for in the first instance is whether there is a hazard, and you look to a variety of things, including the published documents. Now, published documents could include journal articles, technical reports, governmental reports. Again, in the context of our discussion today, medical case studies and position papers really are what's key there, and then some of the other items that human factors experts typically look at. So you look at all of those things and you determine, is there really a hazard? Now, if you look at the documents and you determine that there's a potential hazard that is being conceived or is hypothesized by the, in our context, the medical literature, that is not what triggers a manufacturer's responsibility to warn under a human factors analysis, because every day when you look at scientific studies, there are hypothesized hazards that, after being studied further, turn out to be not hazards at all or non-existent. So from a human factors perspective, simply identifying any medical literature is not enough. There has to be a further analysis. Now, when you're talking about analysis of scientific hazards, there are advancements in science and medical knowledge over a period of years, and we'll talk in a little while about the talc and ovarian cancer litigation, and you'll see that scientific studying has been going on for 30 and 40 years. So as the science progresses, it's not always clear at what point some kind of a causal connection is established in science, and that proves to be challenging for manufacturers who are monitoring the studies over a period of time. And lastly, from a human factors perspective, it's not simply identifying any study that discusses a potential association between a product and a particular disease or injury, but it's really the quality of the studies and a critical analysis of the medical findings to really determine whether a hazard exists, and to some extent that goes beyond the expertise of a human factors expert, and you may need to involve either an in-house person from your company who's developing the product if you're using a human factors person on the front end, or if you're in the context of litigation, you may have some other epidemiologist or other type of scientific expert to pair with your human factors expert to make the argument that the science isn't there, therefore there's not a hazard, and if there's no hazard, then there's not a duty to warn. So from a human factors perspective, that's how you would approach this particular issue. Now, the last issue, which to some extent spills over into the regulatory area that Mike's going to chat about in a little while, is the issue of overwarning. Because, one of the questions is, hey, look, if there is a hypothesized or unproven, medical study or studies suggesting an association between a product and a potential risk of injury or disease, why not warn? And the FDA has clearly said that what happens is if you warn about every potential hypothesized hazard, you're going to have a laundry list of warnings on every kind of product. And the reality is, and again, this goes back to a human factors analysis, that people are simply not going to look at all the warnings because there are too many of them, or the real warnings about the real hazards are going to be lost in the long list of the other potential hazards, and the normal consumer doesn't have the ability to sift through the different hazards and assess them. So the FDA in its guidance does suggest that you should not warn against hypothesized or unproven hazards.
But the idea, Joe, if I can just for a second before you move on, the idea of overwarning, if you think of the commercials that you see on television for prescription pharmaceuticals, virtually everybody I talk to laughs at, don't use if, and then the actor goes on for 10 or 15 seconds with a laundry list of potential things that could go wrong. But nobody pays attention to them because I know every single ad has this big laundry list. And I think that's what FDA is talking about, and the human factors people talk about with the dangers of overwarning, that people just don't pay attention.
Yep, that's exactly the point. And so, there is no clear answer from a human factors perspective as to when the literature progresses to a point where there now should be a warning. And you'll see that play out during the rest of the presentation. So that's the human factors approach, and that's the way, whether it be, again, in litigation or before putting a product on the market, a manufacturer would approach assessing the potential hazard of a product. Let's switch over now to a legal duty to warn. And just to be clear, to frame the issue from this perspective, in most jurisdictions, there is a duty on a manufacturer to warn of certain things associated with its product. Legal duty to warn is typically an issue for the court to decide, but what typically happens in this context is when you're focused on whether a company acted reasonably, it is the reasonableness of the conduct that really triggers whether it had a duty to warn in this context. And what we've done in this section is we've used some general concepts to highlight how different states view the duty under state common law. Generally, most states say that a manufacturer must warn of product hazards where those hazards were known or knowable when manufactured. And really what we're talking about here is not what the manufacturer necessarily knew at the time, but what a reasonably prudent manufacturer would have known and warned about. In most jurisdictions, showing a danger is knowable is really a question of whether it was actually known to experts in the field. So the issue here is the manufacturer's initial threshold duty is really to keep abreast of developments in the area and to make sure that it understands scientific developments and monitors them, because that's the standard to which a manufacturer will be legally held under the common law. Now, this is an interesting case out of the Ninth Circuit applying California law, and it really is an interesting weaving of the legal duty issue along with the human factors approach. The court held that the manufacturer was held to the knowledge and skill of an expert in the field and obliged to keep abreast of scientific discoveries and presumed to know the results of advances. Again, that's what we just talked about earlier. But here's the key: a manufacturer is not under a duty to warn of every report of a possible risk, no matter how speculative, conjectural, or tentative, because inundating the public indiscriminately with notice of any and every hint of danger would inevitably dilute the force of any specific warning. And that's what that was the example that Mike mentioned a couple minutes ago. Also, reports of isolated or speculative injuries do not constitute generally accepted medical knowledge. So in the context of a case like this is where your human factors expert may come in, and this is where your science experts may come in to convince the court that there is no scientifically established hazard, therefore there's no duty to warn. And the tension you see playing out in a lot of the litigation nowadays is plaintiffs' attorneys don't wait for the science to evolve to a point where a causal connection is established. They see minimal scientific literature out there, and they use that as the basis for bringing a claim. And so the battleground is whether there's a duty to warn when you have less than established scientific literature out there. And that's essentially what this case discusses in terms of the legal duty. Now, in this next slide, we use California as an example, but really this is representative of most jurisdictions around the country. If we're talking in the context of strict liability as opposed to negligence, the standard typically is a plaintiff must show a danger existed associated with the foreseeable use of the product and that the defendant failed to adequately warn of a, again, known or knowable risk where that failure caused injury. So we're back to the standard of the reasonable manufacturer, and that imposes the duty upon the manufacturer to keep abreast of developments in the literature regarding causation. And again, I guess it's a point worth making that the risk must have been known or knowable at the time the product was distributed. Now, that was strict liability. This is under negligence, and again, it's California, but it is representative of of most of the jurisdictions. Under negligence theory, it requires a plaintiff to prove that a manufacturer or distributor did not warn of a particular risk for reasons which fell below the acceptable standard of care. And we're back again to the what a reasonably prudent manufacturer would know and have warned about. So the takeaway from the state common law legal duty really is a manufacturer legally will be held responsible for keeping abreast of medical and scientific developments regarding potential harms of its product, and will be held to that standard in litigation in most states. Now, there are a couple outlier jurisdictions. Washington State, requires actual constructive knowledge for negligence claim, but not for strict liability. New Jersey, the state-of-the-art defense is irrelevant and inappropriate because it amounts to an assertion of blamelessness. And in Hawaii, in strict liability actions, state-of-the-art evidence is not admissible to show a manufacturer knew or should have known of the danger. But those are the outlier jurisdictions. For the most part, the standard that I discussed a few minutes ago is really the one that would govern in most states in the country. So that kind of frames up what the duty would be under state common law. And now I'll switch it over to Mike, who's going to talk a little bit about the FDA regulatory issues.
All right. I just got to get the mouse in the right place here. Obviously, we're not talking in the kinds of products that we all either are making or selling or representing those companies. We're not talking about power saws or ovens or refrigerators or things like that. We're talking about a very highly regulated industry with potentially different regulatory scheme depending upon whether it's a drug or it's a device, or we'll talk a little bit about cosmetics later. The regulatory scheme arguably can present additional hurdles for a company looking to defend failure to warn claims, potentially and particularly on the issue, which I'll talk about later, and then Joe will expand upon in the TAL context, issues of whether or not science says that A causes B or can cause B, or is scientifically proven to cause B. We'll be talking about, like I said, drugs and devices and cosmetics. So we'll start with sort of general warnings law for drugs and devices. The schemes are fairly similar. This language, for the most part, is coming directly out of the statute or out of the regulatory scheme. Adequate warnings, put that in air quotes, that's a real quote, adequate warnings are needed where the use of the product, whether it's drug, device, or something else, can be dangerous to the patient's health, or where there can be unsafe dosages or methods, or if it's taken for too long, it's potentially an issue. In addition, children need to be dealt with particularly, and if there are particular pathological conditions, we'll let the few, we're good? Okay. If there are particular pathological conditions that a particular substance or device may affect, those need to be spoken about specifically. If you think of the package inserts for pharmaceuticals, there's stuff for pregnant women, there's stuff for children, there's stuff for geriatric population, and depending upon needs, there may be stuff that's race or ethnicity based. So those warnings are required for drugs and devices unless they're exempted. FDA can exempt products from this scheme. Probably unusual, but it can be done. And the warnings need to be done in a way that actually convey the information that needs to be conveyed. Did I go too far? No, okay. I have this quickly moving mouse. Sorry about that, guys. Now, I want to talk for a moment about misleading labeling, because if a product is found, the labeling is found to be misleading, it can be deemed misbranded. And misbranded in FDA context is a very bad thing for a product and a company. So you don't want to be in a position where your product is misleading because it can be deemed misbranded. So what is taken into account in assessing whether or not a product has been is misleading? Representations made by the seller. That makes a lot of sense. Is what the seller is actually saying about the product true or not true? Trying to advance the slide again. There we go. The next couple of factors are interesting because it's the extent to which the labeling doesn't convey information, material information, in the light of representations made by the company. I'll use an example that has hyperbole, but I think makes the point that if a particular product says, okay, the effect of this product is going to be in place in 20 minutes, and they know when that labeling is there, or the plaintiff's lawyers are able to prove later that, in fact, they knew that in a substantial number of patients, or even in some patients, depending upon what's happening, that it takes 2 days. And if that 20 minutes versus 2 days is found to be material and it's been omitted, that can be grounds for the labeling being considered misleading and therefore misbranded. And there's also issues here for drugs and devices that if the company's aware of use other than that it's labeled for, so either off-label use or that their customers are using it on a regular basis more or differently than it's supposed to be, it's the warning against that type of conduct is required. So what are the other factors, or what are factors? Joe, why don't we switch seats because the mouse is not connecting that well. So what does FDA look at least in the drug context, and I think that it's transferable, the analysis is transferable to devices or cosmetics or even non-medical product-related concepts. How often is this happening? How often is it happening relative to the number of uses or the number of products that's out there, number of users that are out there? Are there comparison group analysis of people that use it and don't use it, and is there an increased incidence of disease or adverse outcomes in people using it versus people that aren't? Is there a dose response? If you give more of it or you use it more, does the effect happen? If we're talking about a drug, is the effect that's being seen consistent with the pharmacology of the drug? In other words, knowing the properties of the drug, would you think that this is something that is biologically plausible? Is there a temporal relationship? Is there a time relationship between the use of the product and the outcome? Challenge and de-challenge. If you take the product away, does the incidence of disease go away? And then finally, is it an adverse event that's known to be caused by similar drugs? Again, these are in the drug context, but these are all things that FDA would look to in seeing whether or not there ought to be a warning. If there is an uncleared or unapproved use and there are adverse outcomes from that, that's something that in both the drug world and the device world, FDA wants those warned against. If you do that, you need to have a specific statement in the labeling that says that particular use is not FDA cleared or approved, and that its safety and effectiveness in that context has not been demonstrated. Medical devices, like I just said, it's similar between the two, between drugs and devices in terms of this approach for warning. Off-label use, same thing with devices. And it's beyond the scope of this presentation to get into the details of what labeling goes on what drugs or what labeling goes on what devices. FDA has the authority and does exercise that authority to require specific labeling for drugs or devices. Just as one example, for tampons, there's very specific language in the regulations about what's expected to appear on tampon labeling because of the potential risk of toxic shock syndrome. So they can, if they step in and there's specific language like that, you may have a pretty good preemption argument. Class 1 and Class 2 devices, FDA doesn't clear or approve the language, although they can and often do, and in fact with tampons they did. Class 3 devices, the FDA has got to clear the language, so you have a better preemption argument there. I just included this list of guidance documents because it'll be in the slides and in the materials if anyone wants to look at the language behind the things that Joe and I have been talking about. Cosmetics, the regulatory scheme is similar for cosmetics, and I talk about cosmetics here because the talcum powder that we've been referencing is a cosmetic. The language in I forget whether that's a statute or regulation, the labeling shall, so it's mandatory language, shall include a statement whenever there's a health hazard that may be associated with the product. That's not proof to scientific certainty. Association is not causation, as we all know. The sun came up this morning. I woke up this morning. The sun neither caused my waking up. I actually was up early before dark, so the sun definitely didn't cause me to wake up this morning. And my waking up didn't cause the sun to rise, but it's associated because I got up and the sun came up. That doesn't prove causation. it's more about the cosmetics, why talc is a cosmetic. So now we're going to go over a little bit about the scientific research, scientific literature, and that will tie into Joe when he starts to talk again in a few minutes about the talc experience. So the strength of scientific evidence. I mean, probably most people that are listening to this and watching the slides are aware of medical and scientific literature and have, at least some concept that doctors and researchers write about things that they see. The quality of the presentation depends upon the type of study that it is, depends upon how good the doctors did the study, depends upon whether the conclusions that they're drawing are appropriate for the type of study that was done. So this is simply a graphic that lets you easily see from the top, which is the strongest evidence, to the bottom, which is the weakest evidence of causation in epidemiology. So at the bottom, animal research, case series or case reports would be the weakest form of evidence. It's probably hyperbole to say that it's no evidence, but it's the weakest form. And then a meta-analysis, an analysis that takes all of the controlled studies, aggregates them, and does some sophisticated biostatistical analysis is probably the strongest evidence. So in making this assessment of whether A causes B, that's basically the science of epidemiology. It's the study of causes of disease and health outcomes in human beings. The best evidence includes a study population and a comparison population. There are different kinds of those studies, and I'll briefly outline them in a few minutes. But as a company or as a lawyer defending a case, assessing the kind of study is critically important to making an assessment of whether or not, in the case of the company, do we need to warn about this or not? Do we need to include something about the labeling in this or not? And for the lawyer, is there enough science here to allow the plaintiffs to get to a jury? Now, just for example, I was flying this morning on the plane. I was reading an article in the New York Times that talked about an increased risk of a particular rare type of cancer in breast implant patients. Yes, we're back to breast implant cases. And the article really didn't make clear what the basis of the substance was. I went and looked on the FDA webpage because there was a statement about it. So if you go to fda.gov, you'll see what I'm talking about. And basically, FDA had done an analysis of medical device reports that had been filed and then did a comparison of the types of cancer depending upon whether the implant was a smooth implant or a textured implant. But it was not, as the headline in the Times would lead you to believe, a comparison study that said this particular type of implant places you at a significantly increased risk of cancer over another kind. What's a case report? Case report is simply a description by a doctor of what happened with one patient or more than one patient. It doesn't tell you anything about whether A caused B. It can allow the formation of a hypothesis. You heard Joe talking about hypothesis before, hypothesizing the idea of, hey, I saw this with this particular patient. Is there a causal relationship? Maybe we should look into it closer. Case series is nothing, sounds fancy, but it's nothing more than a bunch of case reports collected together. There are no comparison groups. I talked a few minutes ago about what the meta-analysis is, a study of aggregated, rigorous study. It's an study, you aggregate a bunch of rigorously done studies to see what the overall data tells you. One of the reasons that's important to do is studies may be done regionally. In the Pacific Northwest, the Kaiser group has a lot of really good medical data that epidemiologists use, but the experience in that part of the country may be different from other parts of the country or other centers that have done the study. So it's good to aggregate them together and look at the data as a whole. I'm looking at the clock, and cohort studies, another type of study, clinical trials, basically the comparison group studies that we spoke about before. Animal study is obvious. And So that's a very quick 10-minute overview of scientific and medical literature, and now Joe's going to talk to you about the talc experience and the sort of in real-time litigation that's developing as we speak.
Sure. Thanks, Mike. I think what we've seen in the presentation so far is that if you look at these issues from a human factors perspective, from a legal duty perspective under the common law, or to some extent even under a regulatory perspective, there's a common theme that is woven through all of the different areas, and it's essentially whether there is an established hazard. And a lot of that, when it boils down to what's really important, it's going to be determined whether there's a hazard based on an understanding and assessment of the scientific literature. And that's essentially what Mike just finished going through. And so in the talc and ovarian cancer cases, we're seeing what we believe is going to continue to be a recurring battle between people who are claiming injury without underlying science and whether those kinds of claims will ultimately go to the jury. So by way of background, in the talc and ovarian cancer cases, talcum powder products have been on the market for over 100 years, and it's no secret Johnson & Johnson has been the target of this litigation. And even though its product has been on the market for that long, it has also been studied since the 1960s in the talc and ovarian cancer context, and we'll get into it in a second as to what the plaintiff's hypothesis is. But we're talking, though, a product on the market over 100 years, studies that have been done over 40 years, yet this litigation really hasn't been on anybody's radar until the last year and a half to 2 years when large verdicts started coming out of St. Louis. And so now it's become a hot issue. It really raises the question of, can you hold a manufacturer liable when the underlying science regarding whether the product actually causes, in this case, ovarian cancer, if the science simply is not there? And in absence of established science, does the manufacturer still have some duty to warn or to pass along information to the consumer to educate them as to the potential hazard that isn't established yet? Go ahead, Michael.
And the context for that is multiple statements by FDA that causation doesn't have to be proven before an obligation to warn is triggered. All that's needed is basically reasonable evidence that there's an established association between A and B. So it becomes, and when I said at the beginning, we can't give you an answer because it's this balancing act between what constitutes reasonable evidence that there's an association versus evidence that there's scientifically reliable evidence that there actually is causation. But FDA is clear that you don't need actual proof of causation before you have an obligation to warn.
That's right, Mike. So let's go through the talc and ovarian cancer cases and talk a little bit about them. Here's the plaintiff's hypothesis. The plaintiffs contend that some extended use over some extended period of time of talcum powder in the perineal area causes it to migrate up the vaginal tract, leading to inflammation of the ovaries and, over time, leading to the development of tumors and ovarian cancer. That is, again, very important word. That is the plaintiff's hypothesis. That is the theory of recovery. Now, the interesting part in the context of this case, which is why this is a great model for highlighting the issue that we're here to talk about today, is that many of the health-related organizations don't recognize the causal connection between talc and ovarian cancer. the American Cancer Society has looked at all the studies, which we'll look at in a couple minutes, but the American Cancer Society has concluded that findings have been mixed and that research in this area continues. So American Cancer Society has not taken the position that talc causes ovarian cancer or that women who use talcum powder in the perineal area are at increased risk for developing ovarian cancer. Similarly, IARC has researched the issue, and they put out a monograph which they studied back in 2006, 2007. It's published in 2010, where the organization also looked at all of the studies, and they broke them down one by one, and they concluded simply that talc should be a group 2B carcinogen, essentially meaning that it's possibly carcinogenic to humans. Now, there's a group 2A, which if IARC believed that there was some causal connection between use of talcum powder and ovarian cancer, it would have categorized it as in a different group. But the fact that they put it in a 2B group suggests very strongly that there is not an established causal connection, at least in the eyes of the World Health Organization and the International Agency for Research on Cancer. The FDA, now Mike said a couple minutes ago, the FDA has regulatory authority over cosmetics, which includes talc-based cosmetic products. If you go on the FDA's website today, this is a quote taken exactly from it, where the FDA says these studies have not conclusively demonstrated a link. But the FDA has gone further. In 2014, and again, to put this into context, the talc and ovarian cancer litigation really started to roll in 2013 in a variety of different jurisdictions. Well, in 2014, there was a quote-unquote citizens petition that was filed with the FDA trying to get the FDA to take the position that warnings were required on talcum powder products because of the increased risk of women developing ovarian cancer. And the FDA, again, looked at all of the literature, and their conclusion was, and it's the last sentence from the block quote in the slide here, is that the FDA did not find that the data submitted presented conclusive evidence of a causal association between talc use in the perineal area and ovarian cancer. So the FDA's position today is that there is no established causal link between talc and ovarian cancer. Now, to put that back into the context of duty, in other words, there's no established hazard. So if there's no hazard from a human factors perspective, there would be no need to place a warning on the product. From a common law perspective, if a manufacturer is held to the duty of looking at the developing literature, looking at what regulatory bodies are doing, looking at what health organizations are doing, in this case, if Johnson & Johnson is looking at the FDA and IARC and the American Cancer Society, they're all saying there's no causal link. So that would seem to suggest that there's no duty to warn, and under the state common law, there would be, that they acted reasonably and couldn't be held liable for any alleged association between its products and ovarian cancer. Now, you would think that this is a case that doesn't make it to trial, but we'll see in a couple minutes that some cases have been allowed to go to trial. Let's quickly go through the state of the literature as it relates to talc and ovarian cancer. Since the 1970s, and some say early 1980s, there have been a variety of different studies studying whether there's any potential link between talc and ovarian cancer. And the studies on the slide here all suggest that there is no increased risk of cancer by women who are using talcum powder in the perineal area. There are also some studies that show there is a possible association, not an established causal connection, but simply that it's possible, and the scientists who issued those studies recognized it as a possibility, not an established causal connection. And then you have, lastly, a list of studies where there have been some slight increased risk of the possibility of developing ovarian cancer through talcum powder usage. But if you actually take a close look at these studies, which we don't have time to do today, you will see that they are typically small studies. They are retrospective cohort studies that have been determined by IARC and some of the other health organizations to be unreliable because of certain biases inherent in the studies, or the increased risks are only slight and don't really establish a causal connection. Now, the studies highlighted in red, those are the plaintiff's experts in the talc and ovarian cancer cases. And despite the fact that, for example, Dr. Kramer has researched this from 1982 to 2016, he has never stated in any of his studies that talc causes ovarian cancer. As a matter of fact, in a 2007 study, which is not listed here, he says the exact opposite. However, he's come into the litigation and he's offered causation opinions on behalf of plaintiffs in these cases. So what you're seeing is very questionable, smaller, unreliable studies suggesting a link, or at least a slight increase. You're seeing a lot of the more comprehensive studies showing no increased risk, and then you're seeing some where there's a possible association, but nothing beyond that. Science is absolutely uncertain in this area. Nobody goes outside of this litigation. No scientists have concluded or said that there's an established scientific causal connection between talc and ovarian cancer. So that sets the stage now for what has transpired in the litigation. In the St. Louis cases, starting in early 2016, you have the Fox, the Ristisund, and the Giannichini cases, which all went to trial. Johnson & Johnson was the defendant, along with another Johnson & Johnson company, as well as Amerisys, who was the talc supplier. And in the first two of those cases, well, actually in all four of the cases listed on the slide, pretrial motions under Frye were made to preclude the plaintiff's medical causation experts. The court denied all of those motions, even though the science isn't there, and allowed the cases to go to trial. Well, in the Fox and the Ristisund case, the jury came back, and despite, again, no causal connection in the scientific literature that was established, the jury found for these plaintiffs, awarded both compensatory and punitive damages against Johnson & Johnson and the other Johnson & Johnson subsidiary, but did let the talc supplier off the hook and returned a defense verdict. In the third case, the Giannichini case, which went to trial in October 2016, again, a similar result, except in that case, the talc supplier was also held responsible. Up until that point, the argument that was being made to the jury was not that you even need a causal connection between talcum powder and ovarian cancer, but as Mike alluded to a few minutes ago, there is an FDA regulation that talks about a product that may pose a hazard. And the plaintiff's counsel was arguing to the jury in the first three cases that if the FDA regulation requires a manufacturer to warn of potential hazards that aren't established in the scientific literature, Johnson & Johnson breached its duty under the FDA regulation and should be held responsible. Now, in connection with that argument, the plaintiff's attorneys put on proof suggesting that Johnson & Johnson really exerted, because of the size of the company, exerted undue influence over the FDA and other trade organizations to prevent conclusions that there was a causal connection between talc and ovarian cancer. So, and then the last piece of it was Johnson & Johnson had some bad internal corporate documents, and it was a combination of those three things that really made it very difficult for the defendants to put on a science defense in the case, and that resulted in not only the large compensatory damage verdicts, but the punitive damage verdicts. Now, this past March, only a few weeks ago. The fourth case went to trial in St. Louis, and interestingly, this jury accepted that there was no duty to warn because the science did not establish that there was a causal connection between the use of talcum powder in the perineal area and the development of ovarian cancer. And frankly, that result is supported by the scientific literature, and in our view, from a defense perspective, certainly that is the right result. But here's the kicker: is that in that last case, it was the jury that was allowed to make that determination. In our view, these cases should never get to the jury, and that leads us then to New Jersey. In addition to the St. Louis cases, there were cases pending in New Jersey, I think about 140 cases, and last September, the first case came up for trial. And again, the Johnson & Johnson defendants moved to preclude the plaintiff's medical causation experts on the grounds that there was no established scientific connection between talcum powder usage and injury, ovarian cancer. And contrary to what the judges out of St. Louis were doing, we had Judge Johnson in New Jersey, no relation to Johnson & Johnson, and who, by the way, Judge Johnson actually is one of the authors of, if you like Boardwalk Empire, he actually was one of the authors and wrote that storyline in that series, so he's a real fascinating guy. He decided to hold the equivalent of a Daubert hearing in New Jersey, which is referred to as a Kemp hearing. And the defendants moved to preclude Dr. Kolditz and Dr. Kramer. Remember Dr. Kramer from the list of studies where they found some slight increased risk? Well, he was the plaintiff's expert in the New Jersey case that came up. Judge Johnson, he conducted a hearing over 7 days. He considered over 100 treatises, heard 9 experts testify, and he issued a 33-page decision with 5 appendices. And what he essentially said is, with respect to Dr. Kolditz, who is the first plaintiff's expert, he went through all the scientific literature, he looked at it, he assessed, meaning Judge Johnson, he assessed it, and he ultimately decided that Dr. Kolditz failed to make a systematic review of the scientific literature and has ignored the rudiments of the scientific method in arriving at his conclusion. And on that basis, he precluded Dr. Kolditz from testifying. And again, that's the right result because the bottom line is that the scientific literature simply doesn't support a theory of a causal connection between talcum powder and ovarian cancer. Now, similarly, with respect to Dr. Kramer, Judge Johnson reached a similar conclusion after breaking down the literature and then analyzing Dr. Kramer's approach and his methodology. He simply said that the analysis was highly speculative and does not conform to any methodology utilized in the scientific community. And as a matter of fact, Judge Johnson goes on in the opinion to talk about the fact that Dr. Kramer has never said in his published literature that there is no causal connection, yet he's trying to come into court and offer that kind of an opinion here, and he simply says that the science doesn't support it. So contrary to the St. Louis cases where the juries had to struggle with the scientific issues, the New Jersey court essentially dismissed the first cases that came up prior to trial because the science simply doesn't support the causation theory in the case. So where does that leave us? That leaves us now, or that leaves Johnson & Johnson, I should say, and the talc supplier. It leaves them in this odd position where you have large verdicts coming out of St. Louis where the courts are ignoring Frye and Daubert standards and juries are ignoring, for the most part, scientific defenses where there is no causal connection. And then you have New Jersey, which is reaching the exact opposite conclusion. But nevertheless, what you have now is a flood of litigation. You have thousands of cases pending in various state courts across the country. You have a federal court, MDL, that's been formed in the District of New Jersey, which includes a couple of class actions, 54 related actions, and 20 different district courts that have been consolidated there. And so you have some major national litigation surrounding talcum powder usage and ovarian cancer. And this really now brings home the issue that we've tried to discuss with you today, which is, again, to put it back into context, Johnson & Johnson has a product that's been on the market for 100 years. Johnson & Johnson has defended its product. Johnson & Johnson now has thousands of lawsuits against it. By the way, the product is still on the market. The FDA says there's no causal connection. It doesn't require a warning. IARC says that there's no established causal connection. The American Cancer Society, as well as other health organizations, say that there's no link. And despite all of that, those conclusions, here you have a manufacturer who is fighting the battle in state courts and in federal courts over whether their product is causing injury when there simply is no scientific proof. So if you're a manufacturer in that position, the question becomes, when do you warn? Should you warn? Should Johnson & Johnson put a warning on its product at this point? Even though it doesn't believe that there's any causal connection. Should Johnson & Johnson put some other kind of informational warning on its product at this point? Should Johnson & Johnson continue to defend its product and say, there is no causal connection, it doesn't require a warning? These are interesting questions, strategic questions, both from a litigation perspective as well as just from a marketing perspective going forward. So it's a difficult issue, it's a challenging issue, but it is, in our view, something that you're going to see in the products world, in the medical drug and device world, as well as in the world we live in, which is litigation, in the coming years, because plaintiffs have become very aggressive in pursuing claims that simply don't have any established scientific support. So then that leads us lastly to what are our lessons and takeaways from what we've discussed. Mike, I'll hand it back to you. Why don't you go through a couple of them, and then we can wrap this up.
Sure. And some of this is obvious, and it's most likely something everybody is doing anyway. But I know when I attend things like this, hearing the obvious sometimes is helpful as a really good reminder. Obviously, the relevant medical and scientific literature for the product needs to be monitored, but as the talc example may help illustrate, not just the product, but the component parts of the product. There may be major, obviously talcum powder is mostly talc, but if you're making a cream that's got a bunch of different substances in it, and the medical literature starts talking about disease potentially associated with one or more of the substances in that cream, it's probably worth taking a peek at it and seeing what's going on. Number two, and these are not in order of importance, carefully consider the adverse events and medical device reports that are coming in, looking for trends and things like that. Again, that's risk management 101. But the always a balancing act, that comes from FDA's language that says you can't wait until it's scientifically proven that a reasonable association is enough to trigger the duty to warn in the life science world. What's that reasonable suspicion? In the talc incident, virtually all of the relevant cancer organizations conclude that there's not a causal link, but the courts are letting that evidence in. Would a warning have prevented those cases? In my view, probably not, because there would have been quibbling about the wording of the warning. Should it have been said differently? Was it being reported accurately? If you say something like there's a reported association between A and B, a human factors warnings expert will come in and be able to come in and pick apart the language. So you're better off being in the position J&J is right now, which is saying, look, there's no proven association. FDA has specifically said there's no proven causal association link. Where are you better being? And that's a judgment call. But it is important to not wait until you or others decide it's scientifically proven. It needs to make the analysis earlier. Joe, you want to finish up with the overwarning things that we spoke about earlier? And I know the hybrid information was something you were interested in.
Yeah, we talked a little bit about the overwarnings before, and that's certainly a concern. Again, if you're putting the product on the market, working with a human factors expert, you really have to balance what real warnings should be on the product as opposed to ones that simply shouldn't be there because they're not real hazards, and that's a difficult analysis, but certainly a consideration. What I happen to like is the last thing on this slide is considering a hybrid informational warning. Mike and I were involved in a major legal battle over a period of many years over a particular product that was on the market where there was some scientific literature out there hypothesizing about a connection between the product and disease, but it wasn't established. Now, we ultimately, through Daubert and Fry challenges, got all of the plaintiff's experts precluded. That took a number of years. In the interim, the client made a decision to put essentially an informational statement on the product, and it was to the effect of, it has been reported that, X and this may be associated. So it's not a concession that there's a causal connection, but it's simply sharing information about the state of the scientific literature that is out there, and that goes back to what is the manufacturer's duty. The manufacturer's duty is to keep abreast of the scientific literature. Well, the hybrid informational warning really is an attempt to convey that literature or to convey that information to the consumer, so at least the consumer is on notice. And as a matter of fact, in the talc and ovarian cancer context, that's exactly what the plaintiffs have been arguing. When IARC came out and said that that talc is possibly carcinogenic, the talc supplier on the MSDS sheet that it provided to Johnson & Johnson actually had that statement as to how IARC categorized talc. And Johnson & Johnson did not pass that statement along to the consumer. Well, the argument at trial was Johnson & Johnson, at a minimum, should have passed that information along. That's a very different argument than, do I have a duty to warn of an established hazard? So we're seeing this evolution now of a different type of duty that's playing out in trial. But I think one thing to consider is this type of a warning without a concession that there's a connection may be a way to protect a manufacturer who may be facing this type of a claim. So, and then lastly, the last consideration is retaining, again, and I think this is in the context of litigation that you're facing, whether it's FDA warnings or human factors warnings experts, to build your defense that the company acted reasonably because the state of the scientific literature was not established, and that from a human factors perspective, no warning was required. So that kind of wraps up our presentation, folks. We'd be happy to take any questions, Sonia, that may be out there, but we thank you for your time.
Okay, we do have a few questions. We're now going to begin the question and answer session. If you have a question, please feel free to submit it using the question and answer panel located at the bottom of your screen. After typing your questions in the space at the bottom, hit the send button. Please be sure to direct your questions to all panelists in the Ask menu. Your questions will not be seen by other members of the audience. And so we have a couple of questions. The first question is, what duty have the plaintiffs argued was violated by J&J and or bulk product companies in the talc litigation?
Yep, and I think Sonia, I talked a little bit about that before. I think the main argument has been that Johnson & Johnson had a duty under the FDA regulations that the plaintiffs argue impose a duty on a manufacturer to warn of things that may be a hazard. And that's to some extent a departure from the common law duty, from a human factors approach, and from what we would normally see in litigation. So I think that the plaintiffs are overemphasizing the impact of this particular CFR regulation in terms of it creating a duty, but at least in St. Louis, that's been the argument on duty. And the other piece of it was what I just mentioned a minute ago, is this new and slightly different duty of passing along information. And the talc suppliers, again, on the MSDS sheets, would include a statement that IARC has classified talc as a Group 2B carcinogen. And that information was passed along to Johnson & Johnson, and the plaintiffs argue in this case that that at a minimum, that information should have been passed along to the consumer. And so from a duty perspective, that's what's been argued, and it's obviously doesn't matter in New Jersey, because if there's no established hazard, then there's no duty. In St. Louis, where they're applying Fry and they're allowing the cases to go to the jury, it's a major battle over what Johnson & Johnson as a manufacturer should have been doing in these cases.
Thanks, Joe. I have a couple more questions. The first one is, again, a duty-related question. Is there a difference in the duty to warn physicians who control the use of a prescription device versus warning patients directly?
Well, hey, Sonia, it's Mike. It depends upon whether it's a prescription device or not. I mean, most states, the duty to warn runs to the physician that's using a prescription drug or device, and the appropriate warnings need to be provided to the physician as opposed to the patient. There have been efforts made over the years with the proliferation of direct-to-consumer advertising to abrogate that rule and make the rule be one that concerns the warnings given directly to the patient, but those efforts so far haven't succeeded. For non-prescription devices or drugs, it's warning for the consumer.
Got it. I have a question here. I thought it was a very interesting question. How would a hybrid informational warning be labeled, as a precaution or a warning?
I don't think it necessarily would be labeled as either. In the case that we did mention, and it's interesting. Again, we had case reports that came out suggesting, according to the author, a possible association that they were speculating about and that they hypothesized about. The FDA eventually did get involved and took a hard look at the connection, and ultimately the product manufacturer decided to put on an informational warning, and it didn't have any label at the front. It simply said there are reports that X may be associated with Y, and that was it. And you know what? The FDA, under the circumstances where there was no scientifically established causal connection, they were perfectly happy with that kind of a compromise. By the way, that product is still on the market. If you go into your supermarket and you pull it now, it contains that statement, and the FDA has taken no action. And actually, the litigation has essentially gone away because the cases where the plaintiff's experts have been precluded under Daubert or Fry and some of the other states, they've all gone up on appeal and have been upheld on appeal. So that's why I think it's an interesting compromise, because it passes along information without any concession that there's a causal connection.
Okay. A couple more questions. How does the duty to warn apply to medical trials, or is there a duty to warn?
I think, Sonia, it's Mike. The short answer is yes. The subjects in clinical trials need to sign off on an informed consent. And I would say if there's a hypothetical hazard or a potentially known hazard or a potentially known association, that's something that ought to be in the informed consent.
Right.
It's been a while since I've looked at clinical trial informed consent forms, but my recollection is that there's language like that goes in there.
Okay. And thank you, Mike. And our last question is, how does the duty to pass along information fit within the scheme of risk management when the FDA recognized consensus standard for risk management, ISO 14971, does not account for non-causal hazards?
That was a long question, Sonia. We're actually reading it on the screen here to make sure we understand it before we respond here.
Well, I'm going to admit that I haven't read ISO 14971 definitely recently, so I'm going to that's a question that I'd like to, Sonia, if it's okay, can we address that offline, and we'll do it, but I'd like to take a look at it before just speaking off the top of my head.
Yes, of course, no problem. Okay. Well, that concludes our presentation for today. We welcome our listeners to access the recording of today's seminar that will soon be posted on our website at www.medmarc.com, located in the News and Resources section. Our next month's webinar will take place on Wednesday, April 19th, and will feature Terry Dunlap, founder and CEO of Tactical Network Solutions, who will discuss cyber breach. Please watch your email for invitation. Thank you, Mike and Joe. Thank you, audience, for joining us. This concludes today's webinar.